All right, so now I think we're ready for the second panel, which Nancy Rosenblum is going to chair.
Welcome back. I'm amused at the schedule. It's session 2, Reflections on the Right to Religious Accommodation in the organizers' vain attempt to differentiate the panels from one another. We're just going to have global conversation. And then the time, 10:45 to 12:05, in a also vain attempt to control all the time. I'm going to forego introductions because you have an excellent program that lists everybody's place and laurels. I've asked the panelists to keep their talks to under 15 minutes, which is more time than the others have had, but in exchange, they're not going to talk to one another. We're going to open it right up to the audience after the fact. So we're going to begin with Sally Gordon.
Right. Do you want us at the podium?
Whatever you feel comfortable doing.
Let me head to the podium. Stand up and show my colors. I want to pick up a bit on where Mark left off last evening with the corporate form, and also with Louise's plea for us to remember that there are individuals involved in lawsuits and corporate behavior. I want to persuade you, if I can, from the lesson of the legal historian, that our own legal, political, and religious history tells us that both a regulated environment and an intensely creative religious life have coexisted for substantial portions of our history. So in that sense, the conflicts we're talking about here may well be less dire than we often paint them, and both states and state organizations and religious folk and religious organizations are more resilient than we give them credit for. In significant part and for significant portions of American history, we have overlooked, honestly, and in these discussions, religious life and the change that happens there. So let me dig into my story, my history. It starts at the very end of the American Revolution, which, in case any people don't remember that, is 1783. The next year, states first in the Mid-Atlantic and then almost every jurisdiction enacted protective legislation for religious property. These were general incorporation statutes for religious organizations. In other words, religious corporations are the first private corporations in American history. These statutes weren't identical, but they shared basic terms. So in this sense, by 1800, there was a broad system of the corporate law of religion, almost 60 years before general incorporation was made widely available for business entities. So let me get to how American legislatures went about protecting and regulating religious societies. I must admit, I'm lumping rather than splitting here, and historians in the audience will know that's an admission, meaning I'm piling things on top of each other that we could, if we wanted to, tease apart. But let me just lump for a few moments. There are two main elements here. The first is property. Most statutes limited the amount of property that a religious corporation could own. Sometimes it was in spatial terms, 1 acre, 2 acres, 4 acres. Other times it was only so much as is used directly for worship and burial. In other statutes, the limits were put in monetary terms, $1,000, $3,000, $10,000 in total property value, or annual income, $600, $900, $1,200. Especially in New York, sometimes limits were set by denomination, lower for Quakers, higher for Presbyterians. It's amazing. And in some jurisdictions, several important ones, religious corporations were required to get judicial and or legislative approval before they could buy or sell land, including independent valuations of the market value. So these property limits actually were ubiquitous, and they sound startling to us today. But honestly, they didn't cause all that much trouble. It's the second element in these corporate statutes that caused much more trouble. This is the element that dictated how religious corporations were to be managed. Trustees were the answer. The use of trustees blended sort of equitable traditions with substantive laws, and state legislatures required religious corporations. So if you want security of property, you incorporate, and then you are required to have trustees elected by the congregation. Often, clergy were prohibited from serving as trustees, but not always. Usually, an uneven number or range of trustees, 3 to 15 trustees, or 5 or 7, was required, and almost always they served staggered terms. Once the trustees were elected, they were the corporation. All property was vested in the corporation, and they were given management of all assets. In other words, the collectivity we've been thinking about is described not by a denomination, not by a bishop, but by the trustees. It's really a different way of thinking about religion. And I have to tell you that quickly and perhaps predictably, trustees became troublesome. Technically, they were the legal owners of religious corporations. Some began to think of themselves as owners in all senses and treating ministers, priests, rabbis, bishops, presbyters as servants, hired and fired to serve their corporation. You can imagine how difficult this local control was for Episcopal denominations, that is, those with bishops, tiers of priestly authority, and even moderate hierarchy or centralized creation of doctrine and affiliation. I could go on and on and on about the ways that the trustee structure supported dissent and schism. I also want, though, to focus on the ways that protection of individual congregants, their capacity to elect trustees, for example, protection of these individual rather than institutional rights in religious groups was crucial to the religious freedom of people who endured the most dire of discriminatory regimes. That is, enslaved and formerly enslaved Americans of African descent. The corporate law of religion empowered African American worshipers. Historians of religion have long been familiar with the appearance of African separatist congregations in Philadelphia and other eastern cities, including southern ones, starting in the 1790s. What we have lacked is a legal history of this crucial institution building. The first 2 corporations formed by African Americans were formally approved by the governor of Pennsylvania in 1796. Bethel African Methodist Episcopal Church and St. Thomas African Episcopal Church both still exist today, a testament not only to the longevity of the corporate form, but also to the determination of their founders and successors. These corporations illustrate the value of independent religious agency and the relationship between individual rights within religious organizations and the capacity for nation building. Richard Allen, the founder and first bishop of Bethel Church, and Absalom Jones, the founder and first African-American priest of the Episcopal Church, had been lay members and lay exhorters, that is, evangelists, of St. George's Methodist Church, now known as Old St. George's in Philadelphia. They left in the early 1790s when Jones was told he could not sit in the most desirable pews in the church where he had long been used to worship. Most, but not all, Black parishioners left with Jones and Allen. Soon, a schism developed within this schismatic group. Jones wound up taking most, but not all of those who had walked out of St. George's and formed St. Thomas's Church and filed for incorporation in early 1796. Weeks later, Richard Allen's smaller and much poorer Bethel Church did the same. Bethel stayed allied with Methodism, however. The Articles of Incorporation for Bethel were unique in that they protected the racial makeup of the congregation. Trustees were only allowed to be elected by male members of the church of African descent. But the Articles of Incorporation also placed the church building and the earth on which it stood firmly under the control of the Central Methodist Church and under the spiritual guidance of that church. And here's where this law of religion becomes crucial, because African separatist churches made much of the legal doctrine that articulated the rights of trustees to resist the commands of central church structures. They changed and built the law of religion. Bethel's leaders were deeply dismayed by white spiritual governance, especially after the pro-slavery stance of Southern Methodists undermined even the modestly anti-slavery wing of the white church after 1805. When Bethel's trustees learned in 1806 that the new minister of St. George's, a native of Virginia, intended to preach regularly at Bethel, and they were surprised to learn that their Articles of Incorporation gave the minister the authority to do so. A lawyer whom they consulted informed them that the articles were unequivocal on the matter, but he also told them that a supermajority of voting members could amend the articles. Thus, a document known as the African Supplement was written in 1807. This new document asserted trustees' control over the selection of Bethel's ministers. St. George's hired its own lawyer in response, and he advised St. George's to behave as though the African Supplement had never existed. He said the new articles were a revolution, not a revision. But the supplement was registered with the state, and the Attorney General of Pennsylvania validated the supplement with his statement that it appeared lawful to him. And indeed, the law of trustees was in its infancy, and trustees' power grew steadily, in significant part because African churches litigated, not just Bethel, but St. Thomas. But I'm lumping here, so we're going to move on quickly. In cases scattered across the 18 teens, Bethel in particular used this new law of religious corporations to navigate away from old St. George's orbit. By 1815, when yet another white elder attempted to stride up the aisle at Bethel and climb the pulpit, he was now trespassing. A lawsuit ensued, and a Pennsylvania Supreme Court decision affirmed the right of Bethel African Methodist Church to exclude the elder and to call a minister of its own. With the backing of the courts, Bethel became the mother church of a brand new denomination, the African Methodist Episcopal, or AME Church, now a venerable and international body. This history of state regulation of religious corporations is long and generally unstudied, remarkably unstudied. It deserves more attention. The clearest message that it sends us is that the rights of parishioners were not subsumed in the central authorities of religious denominations. Just to hammer home the point, schismatic groups within the AME formed as early as 1819, and they, in their turn, were protected by law. This story of race and church formation is central to religious liberty in the United States. The empowerment of lay leaders through trusteeship galvanized the growth and creativity of path-breaking Black churches. This history also established a formidable legacy of both regulation. I'm finishing in less than 2 minutes. Is that okay? Perfect. All right, I'm on my last sentence. Can I recap? Okay. This history also established a formidable legacy of both regulation of religious institutions and individual rights within religious organizations. And this regulation has traveled alongside great growth and innovation among religious groups, creating an amazing and powerful tapestry of religious life in America. Thank you.
Thank you. I'm going to be speaking in pretty general terms, but if it feels too general, just bear in mind that Andy and Nelson have written wonderful papers that are really going to engage closely with several of the cases that I'm going to ignore for the most part, like Elaine Photography and Hobby Lobby. These general remarks are kind of informed by thinking about the Hosanna Tabor case, and so maybe they're responsive to the point that Marty made earlier, which is that that's a case worth talking about in this context too. So this year we mark, indeed we celebrate the 50th anniversary of the passage of the Civil Rights Act of 1964. And of course, during the past half century, a wide variety of anti-discrimination laws and equal access rules have been enacted by the full range of authorities and jurisdictions, from small towns to the United Nations. These measures, in addition to a broad array of policies and programs having to do with education and social welfare and economic opportunity, have done a lot to make more real what might otherwise have remained only an ideal of equal citizenship. And obviously we continue to disagree about the precise content and the best ways to implement this ideal, but this is not surprising, and I don't think it detracts from it being a shared ideal. We are, as the title theme of this conference suggests, in an age of civil rights. And as we remember and reflect on this fact today, I think we should also recall that not that long ago we marked, and we also celebrated, the 60th anniversary of the Universal Declaration of Human Rights. And the Declaration identified, as you all know, the freedom of religion as a fundamental right, grounded in the dignity of every person, because he or she is a person, and in equal measure bears. This right to religious freedom includes, according to the Declaration, the freedom, either alone or in community with others, and in public or private, to manifest religion or belief in teaching, practice, worship, and observance. That is, at the heart of what our friend Michael Perry calls the morality of human rights is the claim, the premise really, that every human person is inviolable. And one manifestation or implication of this inviolability is the right to religious freedom. Now, it's not entirely clear, and it is and will be reasonably contested for sure, what this right entails or what it includes and what it permits and what it rules out. I take it, though, that it involves more than a right to believe or not in God, to pray or not in private, or to worship and engage in ritual or liturgical practices or not in distinctively religious gatherings. What else it might include, whether it includes, for example, a right to reasonable accommodation in cases where the application of general laws would impose a substantial and avoidable burden, that's one of the questions we've been talking about. As we consider these questions, though, again, I think we should keep fully in view the fact that the right to religious freedom is one of those civil rights. Again, it is a fundamental human right, the increased appreciation of which characterizes our age. At this conference, we're hearing and talking a lot about clashes and tensions and conflicts. These are real, they're difficult. I think it'd be a mistake, though, to presume that the dynamic at issue here is religious freedom or religion versus civil rights, rather than religious freedom and among civil rights. The Religious Freedom Restoration Act, for example, like the Civil Rights Act, is a civil rights act. And that particular Civil Rights Act recognizes in some, not all, but some cases, a right to religious accommodation. So when we discuss the feasibility or the justifiability or the wisdom of religious accommodations, we're not discussing, I think, something that's alien or external or hostile to the enterprise of civil rights under and through law. Instead, we're taking up a question and a challenge that, in my view anyway, is inherent in that enterprise. Now, we all know many believe and contend that singling out religious or religiously motivated activities or beliefs or commitments as such for protection or accommodation is unwarranted, perhaps even unjust. Religion, in other words, is said to be not special. On this view, any accommodations or exemptions from general laws that are specific to religion would be defensible, if at all, only on prudential or pragmatic grounds. I take it, though, that religion is special. Indeed, as my former colleague John Garvey once put it, I take it that religion is a good thing, and that this is why it and religious freedom are and should be singled out for special treatment and special respect sometimes in our constitutions, laws, and practices. The fact that we are in an age of civil rights, like the social fact which Fred mentioned, that our national community is increasingly diverse in values and beliefs, this gives rise to new challenges, and it certainly complicates the enterprise of appropriately protecting religious freedom, but I don't think it's an occasion for abandoning or downgrading that enterprise. Now, my impression is that the goal of this conference, the hope for it, is not so much to definitively resolve or to define out of existence the tension and conflict that we observe in cases like Hobby Lobby or Elaine Photography or Hosanna Tabor and so on. The aim instead is to really push each other, and I think to challenge ourselves to better understand, to more fully and sympathetically understand everything that's thought to be at stake by all of us in these cases. So with that aim in mind, it seems to me that conversations about the conflict between anti-discrimination law and religious freedom sometimes reflect incomplete consideration about the idea of discrimination, about when and why it is wrong, and about whether, how, and to what extent governments like ours should prohibit or discourage it. It's easy to say, we all believe, I think, that discrimination is wrong. And because discrimination is wrong, it seems to follow that governments like ours, representative, rights-limited liberal governments, may and should take regulatory and other steps to prevent and remedy and discourage and denounce it. And we're right to believe this. After all, the proposition that human persons are created equal is foundational for us. And yet it's not true that discrimination is always or necessarily wrong, nor is it always the case that governments should or may regulate or discourage it, even when it is wrong. Discrimination, after all, can be just another word for decision-making or for choosing and acting in accord with or reference to particular criteria. We discriminate, we draw lines, we identify limits, we make judgments. We do this all the time. As Larry Alexander's put it, quote, "All of us well-socialized Westerners know that discrimination against other human beings is wrong, yet we also realize, if we think about it at all, that we discriminate against others routinely and inevitably." This is an obvious point, but I still think it's worth making. It's not discrimination full stop that is wrong. It is wrongful discrimination that is wrong, and that we're committed to preventing and discouraging through law. It's tempting and common, but I think it is misleading and potentially distracting to attach this morally powerful label of discrimination to decisions and conduct and views whose wrongfulness has not yet been established. Even in an age of civil rights, there's no reason for governments like ours to ban or regulate or disapprove discrimination generally, as opposed to discrimination that is, all things considered, wrong. Well, what does make discrimination wrong when it is wrong? Andy Koppelman has obviously written more than most people about this question. The answer, probably, though, is that there is no consensus answer, despite Andy's best efforts. My own view, for what it's worth, is that there is a moral truth underlying appropriately focused anti-discrimination laws, and that is, if you'll forgive me, that every person is created, sustained, and loved by God, and has been bestowed an equal dignity that should not be violated. And this is as true for all of us as it is for some. Discrimination is wrong when it denies the equal dignity of every person. Sometimes discrimination does this, and sometimes it doesn't. Whether it does or does not depends. Now, that said, I also think we have good reason to think that governments like ours should not prevent, correct, or even discourage all instances of wrongful discrimination. Some wrongs and some bad acts are beyond a constitutionally limited government's power to correct. Some are too difficult or costly to identify, let alone to regulate. Some are, put simply, none of the government's business. We're committed to equal justice under law, for sure, but also to the idea, in Mike McConnell's words, of a limited state in a free society. What's more, we are, or at least I think we should be, appropriately humble regarding our ability to identify the content of and to operationalize efficiently through law and policy this ideal of social and political equality. You don't have to say, as Peter Weston did, that the idea of equality is empty to admit that its applications are reasonably and in good faith contested. So when we say, as we do, that our civil rights laws, when we say, as our civil rights laws do, that discrimination is wrong, again, what I think we're really talking about is wrongful discrimination. And when we affirm that government should prohibit or oppose it, we mean that government should prohibit or oppose it when it makes sense, all things considered, to do so, and when it's within the constitutionally limited powers of government to do so. Now, answering questions about whether or not discrimination is wrong and whether or not governments may or should use civil rights laws to forbid it, these questions require, I think, careful consideration of a number of factors. Who is the decision maker? Who are the affected parties? What criterion did the decision maker employ? How will the decision and others like it affect our ability to appropriately respect and to vindicate the equal dignity and citizenship of persons? How costly would it be to try to prohibit such decisions? Would allowing or accommodating the conduct in question undermine what Andy has identified as the various purposes of anti-discrimination law, including the amelioration of economic inequality, the prevention of insult and dignitary harms, and even the reshaping of culture through the stigmatizing of prejudice? Is the decision at issue one that a constitutionally limited state in a free society should attempt to supervise? In other words, and as usual, context matters. It's not enough, it seems to me, to label a particular decision invidious or odious or some other word. So what about accommodation of religion? What about cases in which there appears to be a tension or even a conflict between the fundamental right to religious freedom on the one hand and civil rights laws that aim to promote equal citizenship on the other? Well, discrimination that's motivated by religion or that is engaged in by religious believers or institutions or that uses religion as a criterion is sometimes wrong. The fact that discrimination is done by religious actors or for religious reasons doesn't mean that it's not wrong. Doesn't mean that it is wrong either. The government should not engage in such wrongful discrimination, and it should sometimes discourage or prevent non-state institutions and individuals from doing it. At the same time, discrimination on religious and other grounds is sometimes a dimension of the right to religious freedom that governments may, and perhaps in some cases even must, allow or accommodate. Sometimes a government like ours will, may, or should regulate discrimination that targets religious status or that is motivated by religious belief or engaged in by religious actors. But sometimes, on the other hand, a government like ours may, will, and should protect or at least leave alone such conduct. Sometimes it's wrong. It's wrong in a way that implicates the appropriate concerns of constitutional governments for religious actors to discriminate, but sometimes it isn't. In the former type of case, such a government will want to respond, and so long as it is within its authority and not too costly to do so, probably should respond. But in some cases, it shouldn't. Now, to say all this is not to be blasé about the ideal of equal citizenship or complacent about the threats that both state and non-state discrimination pose to it. We're deeply committed to the anti-discrimination norm, and we believe that the coercive and expressive and pedagogical functions of law should be deployed against wrongful discrimination, sometimes. We're also irrevocably committed to rights-limited government and to the freedom of religion. And these commitments, as we're seeing and discussing, can be in tension under conditions of social pluralism. We cannot avoid trade-offs, compromises, sacrifices, and perhaps even what Mark DiGirolamo calls tragedy. We should be aware, then, that the rhetorical and the moral and the legal power of the anti-discrimination norm has the potential to distort and perhaps even to distract our thinking about how we protect religious freedom through law. This is because the near universal, if sometimes unreflective, conviction that discrimination is wrong means that assertions of religious freedom are sometimes heard as requests that we tolerate a wrong, that is discrimination, that we would otherwise want to prohibit or penalize or discourage. And then these requests raise the question, well, is it worth it to do so? Or would doing so complicate too much or with the government's projects or conflict too glaringly with our values? And so when accommodations are granted, they're sometimes regarded entirely as concessions. And of course, sometimes they are. Sometimes we do and probably should think about honoring rights in terms of protecting or simply tolerating a liberty to do even the wrong thing, so long as it's not too wrong. But we should not forget that one dimension of the freedom of religion, the fundamental human and civil right to freedom of religion, is, not often, but sometimes, precisely the freedom to discriminate, and that this freedom should be protected, not simply because such discrimination is, an all things considered, tolerable wrong, sometimes it is, sometimes it isn't, but because it is inextricably tied to something that's good, a human right, and that is sometimes beyond government's constitutionally conferred and constrained power to address. Thanks.
Thanks so much for having me. I'm going to speak more specifically than Rick did, but I think, but I think it helps at the outset to frame the topic a little bit, because there are various levels of generality in which the broad sort of debate that we're having can be held. At the sort of most general level, of course, you could conceptualize this as a conflict between general laws and sort of conscience or morality. And that's one way of thinking. It's even more general than the one that Rick used. But if you step down one level of specificity, you might conceptualize it as one between general laws and religion, or to use the title of this conference as sort of a guide, a conflict between civil rights laws and religion. But there are more specific disputes yet, right? Some people over the course of the conference are talking about gay rights or LGBT rights versus religion. Or another framing or another branch of that level of specificity might be about reproductive freedom, right? That's been another sort of topic. But even more specific is the topic that I want to address, which is between marriage equality and religion. So I've taken the conference and one other event as a occasion to think about exemptions that are being written into marriage equality laws for religious groups. I think how you specify the level of generality matters for the arguments. But I'm going to begin at that most specific level and then shift up levels of abstraction in order to test the intuitions that I have about correct conclusions. I'm going to take as my topic statutory law. So statutes, state statutes that write religion exemptions into them. And I'm going to de-emphasize judicial action and also federal law. The method that I'm going to use is a little bit different from the one that Andy uses in his terrific paper. Rather than building up from first principles, I think I'll use, or it's been helpful to me to use, a reflective equilibrium method or a coherentist method. That is, to compare intuitions about concrete cases with our sort of quite confident feelings about settled cases and the principles that abstract from them in a system where you try to sort of achieve coherence and where every element is revisable. The three comparisons in particular have been helpful to me in thinking through this topic. First, a comparison between LGBT identity on the one hand and identity based on race, sex or gender, and religion itself on the other. Second, comparing religion to more general claims of conscience or morality. And third, comparing marriage or conduct on the one hand to claims rooted in identity or status. I think those three comparisons have been helpful to me. As I've thought through the existing exemptions that have been written into marriage equality laws and the ones that have been proposed, I came to what to me was a startling kind of conclusion. I've argued for religion exemptions in the past in various forms, I hope in a careful way. But the conclusion that I came to was different, and that's that even the religion exemptions that have been written into existing marriage equality laws may go too far in important respects. That is, even the states we can assume to be most protective of LGBT rights because they have been the first to embrace marriage equality are carving out protections for religious freedom that are out of step with some of our convictions in other areas. I think we have all the tools that we need to assess this conflict between kind of gay and lesbian rights or marriage equality on the one hand and religious freedom on the other in evolving anti-discrimination law, and that the existing exemptions retrench on the constitutional settlement that's in the process of being articulated in that broader field. The comparison to conscience exemptions for terminating a pregnancy or for distributing abortifacients are, I think, instructive, but don't lead to different results in my mind. So far, most of the attention here has been focused on a debate between people who want broad exemptions for religion in the context of marriage equality and academics who support the existing exemptions that have been written into state laws. But I think that focus should be widened. And our concern should include what has already transpired in state statutes, not just what might happen. I probably won't have time to talk about it, but this has led me to a more theoretical question, which is this. Everyone probably appreciates that the exemptions in current laws were included out of a sense that they were politically necessary to ensure the law's passage. That doesn't mean they weren't principled and don't reflect considered convictions among Americans, though. But I wonder, are these modus vivendi solutions that are revisable, or do they reflect the kind of considered convictions of Americans that we can expect to endure? I think separating out those two phenomena is something that popular constitutionalists have not done so far, and I think that needs to be fully explored, but I won't do it here. So let me just articulate why I think the existing exemptions are problematic. Claims for exemption in this context touch on a breathtakingly wide range of law. Laws regulating various aspects of social and economic life can be implicated. Just a partial list would include public accommodations, employment, housing, government licensing, government funding, and tax exemptions. You can imagine those areas of law kind of arrayed across the top of a matrix. On the other axis, you could imagine the types of claimants that could press for accommodations: churches and houses of worship, religiously affiliated nonprofits, fraternal organizations that have religious connections, government officials or government employees as individuals, private individuals, for-profit corporations. If you imagine this matrix, right, with the types of actors and the types of law arrayed, you can kind of start to appreciate the complexity that might be at issue. I'm going to just take two of those areas as my subject because I think they're the ones that are implicated by existing marriage equality laws. And those are public accommodations, one that Marty raised earlier, and also government licensing. And there are two cases that have kind of served for me as helpful reference points in thinking through those topics. They've also been common reference points in the debate, so I think they'll be familiar to a lot of people in the room, and I won't rehearse them in any great detail. But one is Bernstein against Ocean Grove Camp Meeting Association. Ocean Grove is a town on the Jersey Shore that was organized by a Methodist organization for the purposes of providing a kind of Christian context for kind of summer vacation. It includes a boardwalk pavilion. This boardwalk pavilion is part of the Jersey Shore Boardwalk, the famous boardwalk. And it had been held open to the public for a wide variety of uses for many years. It also, the organization received favorable tax treatment because this was held open to the public. But in 2007, a lesbian couple who lived in the town wanted to use the pavilion to solemnize a commitment ceremony, and the organization refused. The couple complained to New Jersey human rights authorities, which issued opinions saying that the discrimination was illegal in that case. Subsequently, the association stopped holding open the pavilion as a public accommodation and lost favorable tax treatment as a consequence. The other example that's been in my mind is the Catholic Charities case that was raised last night, the one that originated in Boston, where Catholic Charities had been offering its services in adoption and foster care placement to same-sex couples, but stopped doing that when it came to the attention of the church that was going on, and the church asked them to stop. They sought an exemption from state authorities, and that exemption was not granted. This is a licensing case because adoption placement and foster placement agencies must be licensed by the state, and it's a condition of licensing that they not discriminate in Massachusetts. So it's a licensing case, although there are funding implications too. Consequently, Catholic Charities shut down its adoption placement services in Boston. Something similar happened in San Francisco and DC, and also in Illinois, although there it was a funding issue and not a licensing one. Other religious social service organizations have decided to comply with the equality laws and have continued to serve children, and some Catholic Charities affiliates have decided to do so as well and have disaffiliated with the Catholic Church in order to continue to care for needy children. Were these situations rightly handled by the government? I've come to the conclusion that they were. I think there are two general principles that I've abstracted from the cases that help my thinking. One is the principle of full citizenship. That is that citizens should enjoy maximum liberty and consistent with the liberty and equality of others. And the second principle is that the government should, preserve the equal legal standing of all members of the political community. This is the equal citizenship principle. Some people at this conference so far have called this a dignitary principle, and I think that's important too. But in my conception, this is not about feelings. This is about a legal status and the way in which the government either creates or doesn't create different tiers of membership in the political community. Some practices at the core of religious ritual are properly protected by the Constitution, of course, such as clergy selecting which marriages comply with their theology, and decisions by a religious organization to open a sanctuary to particular solemnization ceremonies. I think those are core and need to be protected. But to test my conclusion that these cases were rightly decided, given these principles, I compared them to cases decided on a higher level of abstraction with respect to general anti-discrimination law and with respect to other bases for discrimination, race, religion, and sex or gender and marital status. With regard to marriage equality and anti-discrimination law, I think applying general anti-discrimination law to these cases is not altogether difficult because neither of them had to do with marriage equality. New Jersey did not have marriage equality at the time. Massachusetts did, but Catholic Charities placement activities predated that development, and the church's opposition eventually extended beyond marriage to all same-sex couples. So these cases, though they've played an important role in the debate, are not themselves about marriage, as some people have pointed out. Furthermore, you could compare discrimination on the basis of partnership in same-sex relationships to race, religion, and marital status. And thinking about whether the state would have exempted organizations with religious objections to placing children with couples on these other grounds is also straightforward. There have been arguments that race is different. Kent Greenwald has put forward those arguments in a smart way, and I addressed them in the paper. I don't have time to do that now, but even if the race analogy is complicated, I think the others are far less so. So laws in both New Jersey and Massachusetts also prohibited discrimination on the basis of religion and marital status. Ocean Grove could no less exclude a bride that had been previously divorced in violation of religious teachings, nor could Catholic Charities have refused to place children with couples who were remarried. So there's a lot more analysis in the paper, but my conclusion was that these cases were handled correctly. Now, exemptions currently written into some marriage equality statutes that already exist would reverse these two cases. The Ocean Grove decision is the more vulnerable one. Virtually every marriage equality law that has been passed so far includes an exemption that would overrule that case, except New Jersey itself, which has not passed legislation yet, but in its proposed marriage equality bill would not reverse Ocean Grove. But take Illinois for a recent example. That marriage equality law says no church or other organization whose principal purpose is the study, practice, or advancement of religion must provide facilities for the solemnization or celebration of a same-sex wedding. New York also explicitly exempts nonprofits owned for, or supervised by religious organizations. The key point is this: those provisions apply regardless of whether the facility is a public accommodation. Even if those facilities are public accommodations, they get an exemption under these state statutes. Legislatures have not heard opposition from scholars to this type of exemption. For example, there's a great letter authored primarily by Dale Carpenter to the Illinois legislature, but it does not oppose that exemption. Catholic Charities is not covered by the Illinois exemption, but there are other exemptions in current state statutes that do cover it, like Rhode Island's, and Maryland's exemption also contains language that would protect any religiously affiliated nonprofit from providing services or accommodations to any person if they are related to the promotion of marriage through any social or religious programs or services in violation of religious beliefs. That almost certainly exempts Catholic Charities, I would think, in adoption services, as well as other religiously affiliated organizations. Think of hospitals, schools, community centers that provide a range of services such as marriage counseling, hospital visitation rights, housing for married student couples at universities, marriage retreat centers, and more. Several states have exemptions that are targeted to religiously affiliated nonprofits that have objection to the promotion of marriage through religious counseling programs, courses, retreats, or housing designated for married individuals in violation of their religious beliefs. New Hampshire's law is like that, and so is the District of Columbia's. That's slightly more narrow. In some, the religious exemptions currently written into marriage equality laws by states presumably most protective of LGBT rights would overrule the outcomes in key public accommodations and government licensing cases. And as marriage equality moves into less progressive states, perhaps through political means or perhaps because the Supreme Court of the United States mandates marriage equality nationally, we can expect those exemptions to become stronger and not weaker.
All right, so I'm going to take the podium. Oh, and I should say I'm going to have to leave early tomorrow morning, so if you want to corner me afterward and tell me that I was wrong on why, please do it today. All right, so just a framework for thinking about religious accommodation. There are some laws that just can't tolerate exceptions. Homicide laws, no exceptions, we don't care why. But there are a lot of laws that will accomplish their ends even if there's some deviation from the norm that they set forth. So, military conscription, drug laws, like that. So our question in this context, I'm going to focus on public accommodations and requirements of employer benefits. Our question is whether accommodation is appropriate in this context, whether the law can accomplish what it's trying to accomplish with accommodation. And in order to determine that, we've got to think about the purposes of anti-discrimination laws, because it's about conflicts between anti-discrimination laws and religious liberty. And so I think that there hasn't been enough work done disaggregating the purposes of anti-discrimination laws. Anti-discrimination laws have multiple purposes. And where I'm going to come out is that if you disaggregate these purposes, then businesses that serve the public, wedding photographers, for instance, should be exempted if they're willing to bear the costs of publicly identifying themselves as discriminatory. And that cost is going to make discrimination, I think, rare almost everywhere. But the analysis is different with employers, some of whom also object to recognizing same-sex marriage and to providing, for example, benefits to spouses. They should not be allowed to discriminate in providing benefits because the basic difference is you can always find another wedding photographer, you only have one insurance plan. I think the idea of discrimination as an individualized injury has some of the problems that Nan already identified earlier this morning. If you understand it as individual interest based, then discrimination is imagined to be the conduct of a few bad actors rather than a structural wrong that demands structural remedies. Okay. So just to begin with, I think it's important to understand that the opposition to same-sex marriage, it's a mistake to label it bigotry. It's not really about gay people at all. If you look at how these folks, religious conservatives, think, it's focused on the value of a certain kind of heterosexual union, the good of marriage conceptualized in a certain way. And so if you think about marriage in that way, you haven't discriminated against gay people any more than art museums discriminate against blind people. It's a certain kind of good. Now, I think that these religious ideas that these people hold, I'm just going to offer my own view here, I think that this stuff is hooey. But that's true of an enormous range of religious beliefs. Most Americans probably agree with most Americans surely agree with the following proposition. There are some religious beliefs that are worthless, harmful delusions. We just don't agree on which ones. And that's nothing new. That's the chronic condition of the United States. It's probably the most religiously diverse nation in the history of the world. The way in which we've coped with this diversity is to treat religion understood at such an abstract level as to ignore all doctrinal differences, to treat religion as a good and to accommodate it where this is possible. I have a book about that, but won't go off on that. So what are the purposes of anti-discrimination law? There are three main ones Nelson already mentioned, the amelioration of economic inequality, the prevention of dignitary harm, and the reconstruction of culture to stigmatize discrimination. So let's consider those in terms. The reason why you've got the economic purpose is you're responding to really pervasive discrimination. That's what the Civil Rights Act of 1964 is doing, responding to really pervasive discrimination. And if the discrimination is pervasive, and if the basis of that discrimination is religious, then you can't accommodate. Just to clarify, I think that what I said yesterday was mischaracterized a little bit. I did not say that the people who would have asserted religious objections in 1964 would have been insincere. If you read the historian Jane Daly, she's done some very good work about the basis for discrimination in the 50s and 60s, and people had a religious narrative. That an awful lot of the most racist folks had a religious narrative in which it was invented. You couldn't tolerate it because it would be invoked by lots and lots of people. And compare that with in the United States, you've all heard about the wedding photographer case. You've all heard about the baker who won't bake a cake. Why have you heard about the details of that case, of those cases? Because there's 4 or 5 of them in a country of 300 million people. If discrimination is really rare, it's not going to make any difference. There are plenty of other wedding photographers in Albuquerque. So then we talk about the other purposes of anti-discrimination law. Discrimination is insulting. There's a dignitary harm here. But I think the dignitary harm itself has to be disaggregated. The dignitary harm of knowing that some of your fellow citizens condemn your way of life is not one from which the law can or should protect you in a regime that has free speech. You're just going to have to know this, or you're going to have to give up on free speech. That's your choice, and I'm not ready to give up on free speech. There is the particular burden of being refused service when you're there and you have the face-to-face encounter. And there, it seems to me that there is some analogy between the objection that the religious objectors are making, I don't myself want to participate in facilitating a same-sex marriage, and the objection of the person who contacted the wedding photographer who says, I know there are people out there, I don't want to participate in the ritual of my own rejection. It seems to me that there's an analogous claim here, and I think that both claims are valid and should be honored. In the wedding photographer case, Willick, the woman who contacted the wedding photographer, was induced by a business that held itself out to the public and so invited her to contact them to participate in this and experience this face-to-face insult. Well, there's a line in the New Mexico opinion that rejects her claim. I'll read it to you. Businesses retain their First Amendment rights to express their religious or political beliefs. They may, for example, post a disclaimer on their website or in their studio advertising that they oppose same-sex marriage, but that they comply with applicable anti-discrimination laws. Now, you put that on your website, that's probably enough to persuade gay customers to look elsewhere, but it's in some tension with existing anti-discrimination law, which generally says you're not allowed to announce that there is a protected group that is unwelcome in your business. So here you've got to decide. I take it that in New Mexico, the New Mexico court effectively changed the law and said, here, you're allowed to do this. We said it's okay. I think that that's actually the way to go in this case. That we should allow these people to advertise what they think, and then the face-to-face surprise is avoided. But it's also the case that people who are willing to bear their costs, there's no question there are costs. It is not only gay people who will decide not to deal with you when they see that on your website. One of the things that we're trying to do in religious accommodation is pick out the people who have the strongest religious liberty claims, who really feel very strongly about their religious liberty claims. This is a good way to do that. Now, on the other hand, even a few such notices impose the dignitary harm of living in a world where you have these signs. So Taylor Flynn has an article where she says that this is like a whites-only sign. It's iconic of second-class citizenship. And she worries that this kind of thing could be pervasive. Well, we worry about, how are courts going to gauge how frequent this kind of discrimination is, and Nan worries about this. I think there's no getting around it if you're trying to figure out how compelling the state interest is to make a judgment about how likely the discrimination is likely to be. And here I think that, the fact that the gay rights movement is daily winning and has, these I mean, just look at the shift in the claim of religious conservatives. 10 years ago, they thought they could pass a constitutional amendment against same-sex marriage that would would force the states that had same-sex marriage to give it up. Now they are saying, could we please retreat into our little enclaves and be left alone? In 10 years. I think that a lot of gay people misperceive the situation because their daily experience for many years was one of discrimination and violence, open and unapologetic and hateful. And if you're subjected to enough of that stuff, you're likely to see it everywhere. And it's just hard to get your mind around the fact that the vicious monster who abused you is now in hospice care. But I think that that's actually the world that we live in now. So I think that the gay rights movement ought to be magnanimous in victory here. It just doesn't cost us anything to accommodate these folks. And I've been arguing on the gay rights side for 25 years. It's a weird experience for me to find myself allied with Maggie Gallagher. But here we are. Just lastly about the idea of discrimination as a wrong, because you are licensing discrimination. I don't think that it makes any sense to think about discrimination as a one-to-one wrongful harm, with the idea of private wrong of the kind that Ernest Weinrib talks about in his book on the idea of private law, that we're trying to have corrective justice between those two parties. It's true of some torts. The tort of discrimination doesn't make any sense outside of a social context in which some particular group has been systematically wronged. The tort of discrimination is social engineering all the way down. And if you don't understand that, then, I've got good news for you. The problem of racial injustice in the United States has been solved. Because there's hardly any open, unapologetic racial discrimination. And all of those black people in prison and low-income black people, well, nobody's consciously discriminating against them, so it's all okay. I think that we need to get away from that conception of discrimination. It's working enormous harm. And you get self-congratulatory decisions like Justice Roberts in Parents Involved. Well, we've gotten rid of racial discrimination now. Ain't life sweet? Just a last, I'm running out of time. The stigmatization of anti-discrimination, I think we're not really talking about ordinary policy analysis. We're in the realm of pollution and taboo. Liberal theorists, I think, are uncomfortable with the invocation of primitive impulses like that. They seem to be an ineradicable part of the moral vocabulary of the human race. And in some extent, it's necessary. The stigmatization of racial discrimination and treating it as a kind of taboo probably was necessary in the face of the pervasive racism that's been part of American culture since the beginning. The only way you fight a taboo is with a counter-taboo. And some of that is going on right now. And we see, these ritual public denunciations of someone who is denounced as a discriminator, just got the new CEO of Mozilla to resign because he gave some money to Proposition 8 some years ago. So the relevant prejudice is regarded as ritually unclean. There's certainly value to this, but this weapon is, if you'll pardon the expression, undiscriminating. It can't capture the moral dimension of fine-grained cases like the wedding photographer case. And it's also going to do its work, whatever happens in those cases. Well, the employment law case is different, and Fred already talked so much about Hobby Lobby. I'll just say, when benefits are provided, they're a substitute for wages. I mean, economic analysis shows that. And so if employers are permitted to selectively deny benefits to gay employees because they don't want to facilitate same-sex marriages, the gay employee gets less compensation than the heterosexual employee. And there isn't any alternative to that. The person just is getting less compensation. That violates the purposes of anti-discrimination law at its core and can't be tolerated. This I think part of the reason why this is so hard is because religion has been now taken as a placeholder for discrimination. One of the reasons why so many Americans are alienated from religion is because religion has come to be identified with this kind of discriminatory ideology. And so you get, I think, a growing anti-religious animus on the left. Just speaking to those of you in the room who are on the left, conservatives don't pay attention to what I'm going to say, the American left has never accomplished anything without religious allies. Without religious allies, we couldn't have abolished slavery. Without religious allies, we couldn't have had the New Deal. Without religious allies, we couldn't have had the Civil Rights Act of 1964. If you are concerned about things like economic inequality, then I really want to be able to ally with the Pope, and I don't want to be deterred from that by the fact, which is really hard not to notice, that the Pope is religious. Here, I think that religious accommodation is a way of bridging that gap. Some accommodation of and respect for the religion of the right is going to help us ally with religious folks against the oligarchs who are increasingly taking over the country. Accommodation for the religion of the right can paradoxically encourage the religion of the left. Thank you.
Another goal of anti-discrimination law surely is pluralism. Anti-discrimination law is a way to try to reduce group antimony, group exclusion, etc. And if you look at if you accept that premise that one goal of anti-discrimination law is pluralism, enhancing or integration, encouraging, how does that play out for each of your presentations?
It seems to me that it's a wholly owned subsidiary of the purposes that I already enumerated. If you can empower individuals economically, if you can prevent individual dignitary harm to those individuals, if you transform society to eliminate the stigma that is imposed on those individuals, that will inevitably empower the groups of which those individuals are members.
Yeah, I think John Anazi is going to talk more about this later. He's certainly written about it. But as I see it, pluralism fits into what I was trying to say very well in the sense that I take it that pluralism is well served by allowing for a variety, a range of expressive associations, religious institutions, and so on, and that a lot of these institutions are going to govern themselves internally in ways that are not consistent with sort of norms of liberal governance, right? So I guess I'd say that if pluralism is a goal of anti-discrimination law, that supports my intuition that anti-discrimination law should be applied and implemented in a way that's sensitive to the ability of these non-state institutions to order themselves, even if they're illiberal.
I would say that especially state regulation of religious life in the 19th century was designed to allow for dissent and the formation of new organizations, not to produce it, but to allow for it. So in that sense, pluralism is a result, not necessarily the desired end goal at the outset, but it is most definitely clearly on the mind of state legislatures that they want to protect individual liberty to leave and to change the life of ongoing organizations.
I don't need to add.
Sandy Levinson. Rick, I wanted to pick on our mutual friend John Garvey for a moment, because I'm not sure what it means to say that religion's a good thing. It would be like saying the nation state is a good thing. or any other abstraction. And it seems to me that, that Andy is right, that there are many religions that have simply been dreadful, some of them that no longer are around, like Aztec religions, some of them that are around, and one could, pick examples from any of the leading denominations here or elsewhere. But once one concedes, if one does concede, that religion per se is no more a good thing than, say, the nation state is per se a good thing, that one has to talk about specific religions, specific nation states, et cetera, then where do you go from there? Because it does seem to me that part of the rhetorical appeal of John's position is to try to lull the reader into saying that, yeah, religion is a good thing, even if some religions are better than other religions. There's no such thing as a truly dreadful religion that we're really better off without.
I took John to be saying something different, and you've known him longer than I have, but not that he would deny, how could you, that there are some religious impulses that are or outcomes that are revolting or not good, but that he was using religion in the What Are Freedoms For book, I think in kind of a stylized way, as being about this, search. He called about the search, about the journey, about the reaching for the transcendent and so on, and it was that impulse that I think he was labeling as religion, and that I think, the Declaration and other kind of human rights documents that people like Michael Perry focus on are also thinking about religion in those terms. Not to deny, obviously you can't, Marcy Hamilton makes this point a lot, that you can't pretend that religious motivations make actions good or that religious actors never act badly, and John wouldn't have said that. I don't want to be heard to say that. But I do think more in the way that I think Andy's written about, that, you can talk about religion at a sufficiently high degree of abstraction. Those of us, and I'm not one of them, who are kind of theologically trained or trained in religious studies know that the whole category of religion is slippery and contested and unclear and culture-bound and all that good stuff. But John's point, and I'm willing to endorse this, as kind of a claim, people might not buy it, obviously, sort of a moral anthropology claim, that it's kind of hardwired into us to search for the truth and to cling to it once we find it, and he labels that as religious, and I think that is a good thing.
I just want to take this on, because I talk about this also, because I think that, so in my book, Defending American Religious Neutrality, overpriced from Harvard University Press. I think that this is, in fact, what American law does. And there's the objection. People, the pursuit of the transcendent can have malign consequences. I reach for the sky and I hit the building. It's not, that's not good. The actual claims that come before American courts, though, pass through two filters. I talk about this in the book also. One is the filter of criminal law, that you can't really be an Aztec in the United States. The most malign, are honor killings. Those are out. Even though they're religiously motivated. So those religions just don't thrive in the United States. So the religions that we actually get making claims in the United States are a subset of religion, and a nicer subset of religion than you find on the planet as a whole. And then the other is just the basis of the claims. It's always going to be a claim of religious accommodation that always is going to get weighed against the state interest. So the question of whether religion in general is a good thing, I find more unanswerable than John does. But that's how this practice, I think, makes sense.
Can I go to the microphone? It's going to help. This is, thanks, Andy. Chip Lupu from George Washington University. I guess this is aimed more at Nelson and Andy than at the other panelists. One way to characterize the disagreement between you is that Nelson is just all about principle, right? Let's think about this kind of discrimination compared to this kind of discrimination. Do we really have a reason to treat race discrimination differently from gender or sexual orientation, et cetera? And Andy's all about prudence. It's like, come on, maybe we can make a deal. We'll need the Pope or the Catholic bishops for something else. We'll give up something small, let the bakers and the photographers do what they want. The small ones, people will find someplace else to get their wedding goods, and we'll make deals. So it seems to me that how you resolve this conflict between this is a matter of principle, we should always be consistent, and it's a matter of prudence, we need people in deals, is entirely contingent on time and space and politics. So what makes sense in New Hampshire in 2009, it might have made a lot of sense in 2009. This is how we get same-sex marriage legislation when very few states had it, right? And we think about it a certain way. Now, if you go to Mississippi or Oklahoma or someplace else, if it's going to get same-sex marriage, it's going to get it by court order, right, not by legislative politics. Then it's not clear to me what sort of deal is getting made in exchange for these kinds of exemptions, because the politics of that place and this time seem quite different. So that's a comment, and do what you want with the basis of it, okay?
So that's interesting. I guess I'll take it as an invitation to respond to Andy's point about pervasiveness and whether the discrimination is pervasive and how we should take that into account in our calculations. Because that's sort of a practical point. I think I would respond in three ways. Three sort of questions that trouble me. One is with regard to racial discrimination today, I mean, your question last night was about racial discrimination that's religiously motivated at the time of the passage of the Civil Rights Act. But today, we still prohibit it, even though it's not pervasive, right? So, which is some indication that we still think that there's something valuable going on. And now I'm using this sort of method of kind of reflective equilibrium. Second point I would say is there's an equal, this was Louise's response to your question, there's an equal citizenship component there, which I think is not about the feelings of other citizens, or your reaction to the accusatory or discriminatory feelings of other citizens, nor is it about how someone might feel when the government says something about them. To my mind, I think Pildes and Anderson have this right. This is about a legal status, right? Is the government contributing to the subordinated legal status of members of the political community? I think that's what it's about. And if you ask that question, then I think the pervasiveness variable, I think, matters differently. And third, most of the arguments that Andy's making are about national data. They rely on national data, and they're empirical. You know, how many people are discriminating in this way? But there are important regional variations, right? So it may well be the case, and this is an empirical question, I don't know whether it is, but I suspect that it is, that in parts of the country, religiously motivated discrimination on the basis of sexual orientation is pervasive, right? And when that's the case, then the arguments start to run a little bit differently, I would say.
So just on this point, I'd like to say, if you trust Nate Silver's data, there's going to be majority support for same-sex marriage in almost every state in less than 10 years. So, I mean, there are these places. They are rapidly shrinking and in retreat. Let's see, on the question of principle versus prudence, I think that anti-discrimination law is motivated by concerns of high principle. I wrote a book, Anti-Discrimination Law and Social Equality. I said, you know, if liberalism is going to accomplish what's going to accomplish, if there's sufficiently pervasive protection, you can't even deliver the goods of the Robert Nozick minimal state. And there have been times in American history when the police have been unwilling to afford protection against violence to both gay people and black people, so even the minimal Nozick protections aren't available. That's got to change. But my claim is that the question of whether you can accommodate religion and at the same time deliver this thing that you absolutely must deliver, their prudential calculation comes in.
I wonder, Marty Lederman, I wonder whether this is part of Nelson's matrices and how it would fit in. Is there something to be said for drawing some bright lines, even though they won't be perfect, between what we might call action in the commercial realm and outside of it? Martha last night put this, you know, obviously it's the old public-private distinction. It's very interesting. A brief filed for the United States written by Mike McConnell in Tony and Susan Alamo, this was the very first point of the brief. Basically, the government should get out of the way, and I think this is the sometimes cases that Rick was referring to, when it comes to the internal organization of a religious organization that's sort of trying to remove itself from the public sphere. Hosanna Tabor, you might think of that as Hosanna Tabor. On the other hand, Michael wrote, a religious organization should generally be required to conform its business practices to the rules of the marketplace. Now, Michael, he wrote that for the government, not for himself. But But I mean, I think that's generally where the law has been over many, many years. And, you know, Sally's account complexifies this somewhat. What's public, what's not. And the middle ground cases are obviously the hardest ones, right? So the social service agencies, the adoption agency. Perhaps when you think of Hosanna Tabor, it's a school open to students of all faiths, right? Should they be able to discriminate against students based on sexuality or religion or sex or the like? And they're in the commercial space in some respect, but they're also playing what they see as an internal role. So there are definitely the middle ground cases that are complex. But would it help? I mean, Andy, you seem to resist this and think that even in the commercial setting,
Yeah, you can say, look, it's a very simple, convenient rule. Maybe you've been operating this business for 20 years. Maybe your whole life revolves around it. Sell your business and go into something else. We can't accommodate you. Well, I really want to know that we can't accommodate you is true. If it's not true, then you shouldn't say it.
Let's collect 3 or 4 quick questions in a row, because we're running out of time. Yeah.
This is a question for Nelson. You referred to the ministerial case as the core case of activity by a religious group. And the suggestion is, I think, excuse me, that providing adoption services or other social services is not at the core of religion. And that seems to me an ironic thing to say from a progressive standpoint. And I've made this, Tom Berg, by the way, I've made this point in other contexts. So what would your answer to that be, given that progressive religion is very much focused on serving others, and what progressives value in religion for the most part is its service to others? Isn't it undercutting that to say this isn't really the core of religion, or to make those kind of distinctions?
Very quickly. You want to answer very quickly?
You can collect.
Yeah, let's collect some questions. Next.
Hi, Aram Chevet, personal capacity, but with the Center for Reproductive Rights. One very brief point and then a question. The brief point just being, I think the point was raised by a previous questioner, making the distinction between sort of religion as a whole and talking about individual religions. I just would remind people, of course, that no religion is monolithic, and we talk about the Catholic Church, but of course the Catholic Church speaks out against contraception, but we know 98% of sexually experienced Catholic women have used contraception and so on. Just a point just to keep in mind as we talk about these things, that we don't do so monolithically. The question I have is sort of trying to square the circle a little bit between Nelson's point and Andy's point about public accommodations, which is clearly a public good, and the concern about, do we really want to go after these small fry in their last gasp? And I wonder if one distinction to draw between them is not necessarily the large versus the small, but public accommodations where it's sort of a generic item that is being handed over, whether it is, you can use this pavilion, you can have access to this hotel room, as opposed to something like the Elaine case where someone is being asked to use craft, their art, their judgment. I don't know how to, maybe a craft as opposed to something like that. And whether that's a possible line of distinction is between, let's say, a hamburger that's handed over in a fast food restaurant and a speechwriter who's being asked to compose a speech celebrating a marriage with which she may not agree.
Anybody else? Then let's give our panelists a very brief amount of time to answer.
Okay. Tom, I appreciate the question. And I didn't mean to say that it was core in the sense that for those religious people, this was a core activity versus serving the poor, which is not a core. That's not what I meant. What I meant by core was I guess it's a version of the public-private distinction. Like that's activity that's serving their own community that doesn't have public ramifications. I think should be fully protected not only by statute but also by the Constitution. Whereas it seems to me that when a social service provider goes into the public and provides services to the public, not discriminating on the basis of who they bring in, who they're serving, well, I guess what I mean is they ought to be open to and accepting of government regulation that sort of determines how that's best performed in the public sphere. So that's not articulate, but that's the distinction I meant to draw.
Just about the free speech claim in the Elaine photography case, what worried the New Mexico court about this was that they would have to generate a whole new body of law in which we figured out which professions are expressive and which aren't. archaeologists will tell you that all human artifacts are expressive. That if you think that the way in which the vegetables are arranged on the plate with the hamburger is not expressive, you haven't thought very much about what the serving of food conveys. So I don't think that there's a good road to go down.
I guess if one more blast from the past, if there was ever anything that was viewed as internal, it was the designation of priests, ministers, and rabbis. And what the courts held consistently was that a central church authority may be able to appoint a priest, but whether or not they would be paid would depend upon the trustees who held the power of the purse.